May I request anyone who is presenting? The one who is presenting can please stop presenting. May I request Pooja to please stop presenting? It is requested by everyone not to present. छोड़ो यार, हाँ बोलो. May I request Puru Tiwari to please stop presenting? Puru Tiwari, you are supposed to not present. We would be obliged to remove you out of the group if you stop. May I please request Puru Tiwari to stop presenting? This is the final warning to you, otherwise we are obliged to remove you from the group. Is it audible? No, it was just a trial.
अरे वो भी गई है ना। अच्छा ठीक है, रहने दो।
I request everybody to please switch off their mics. Sunayana, Khurana, will you please switch off your mic? Mr. Puru Tiwari, will you please stop presenting?
So we'll be join. Hello, am I audible to you all? So we'll be starting the session by 4 exactly, which is the time now. Salman sir will be joining us at 4:15 sharp. I request each one of you to switch off your microphone, that is to put yourself on mute. Don't come and go. If you all want to switch off your camera, just turn off your camera because you are going live on YouTube right now. And don't present your screen. Anyone who is found presenting the screen while the live session is going on will be removed ASAP and his e-participation certificate would be revoked. I now request Ritika to please start the proceedings.
Okay. Good evening, all. We, on behalf of Legis Orbis family, welcome you all to the first webinar series of Legis Orbis classes. The concept of Legis Orbis online live classes was the brainchild of our founder, Mr. Abhishek Chaudhary. When we joined with him in his idea, we estimated the participation of around 50 to 60 students. But to our utter surprise, the first phase of this free online live classes witnessed a massive participation of around 150 students from around 67 plus law schools in India. We initially thought of having two batches, but seeing the enthusiasm of students, we decided to provide free classes to 8 batches covering 4 important law subjects. We presently have in our team Mr. Abhishek Chaudhary, Ms. Ritika Ritu, Ms. Rajshri Kanungo, Ms. Radhika Sharma, Mr. Devrat Shukla, Ms. Shraddha Das, and Mr. Sabyasachi Panda. And we are growing. The idea behind the concept of Legis Orbis is to help the students in India and abroad to acquire a broad understanding of Indian laws. During this phase, when everyone is going through turmoil, while dealing with the struggles of their lives, we have come up with the idea which would contribute in sharing of problems from their shoulders to ours. And thereby, we are making a positive contribution towards a positive nation building. What we are trying to show that despite all negativities prevailing around due to pandemic situation, we all can contribute in making a positive environment. And the idea of Legis Orbis is a prominent example. From not only the students of law, we have received appreciation by the bench, by the bar, the corporate houses, the academic institution, universities, and the people at large. Today, when we are starting our first webinar series, we have the blessings of the former Minister of Government of India and the Senior Advocate, Supreme Court of India, Shri Salman Khurshid, Mr. Ashok Arora, Secretary, Supreme Court Bar Association, Ms. Kanika Dasan, Consultant Legal, World Health Organization, and Mrs. Kavalya Garikapati, Senior Assistant Professor, KIT University. To our honor today, we have with us Mr. Salman Khurshid to address the session, which will focus on the career opportunities for law students during and post-pandemic, with special focus on new norms of litigation in India. Now, may I hand it over to Mr. Abhishek Chaudhary.
Thank you, Ritika. So, at Legis Office, what we are doing is we are collecting people, we are collecting students at one single platform, and we are imparting them legal education. We are trying to help them understand various concepts of law. And as a part of our online law classes, which is a pro bono initiative, we have right now 8 batches consisting of 150 plus students uh, from 67 different law colleges and universities across the country. As a part of our online law classes, we have started various curricular and co-curricular activities. We are conducting an online law quiz competition, and our second initiative is this webinar session, to which today almost all of you are part of. We have live audience on Google Meet from almost around 100 people sitting at different part of India, and hundred of participants are watching us live on YouTube as well. Today, to do the honors to address our gathering, virtual gathering, as a part of this first webinar series titled Career Opportunities for the Law Student During and Post-Pandemic Phase, we have with us Shri Salman Khurshid. Shri Salman Khurshid is a renowned lawyer, educationist, writer, politician who in 1953 was born into a distinguished family of educationists come national leaders who have served the country with great distinction for over three generations. His maternal grandfather, Dr. Zakir Hussain, was a close associate of Mahatma Gandhi and went on to become the third president of India. His father, Shri Khurshid Alam Khan, was a noted parliamentarian, Union Minister of the State for External Affairs, and also the Governor of Karnataka and Goa. Shri Khurshid earned his BA English Honours from St. Stephen College, Delhi, and MA BCL from St. Edmund Hall, Oxford University. Shri Khurshid is an educationist and served as president of Delhi Public School Society from 1992 to 2005. Salman Khurshid is an accomplished lawyer and a designated senior advocate of the Supreme Court of India. He has held he has held important position in Government of India and served as the Union Minister for the External Affairs, Law Minister and Minority Affairs. Mr. Khurshid has been active in the political arena of India for almost 3 decades. His books include the play Sons of Babur, At Home in India, and Triple Talaq. Mr. Khurshid will be joining us exactly at 4:15 p.m. and I therefore request you to please bear with us for a few minutes by the time we connect us with Mr. Salman Khurshid. Thank you.
I request everyone to please turn off your camera. I repeat, I request everyone please to turn off your camera.
Mr. Puru Tiwari, please turn off your camera. Mr. Jishan Alam, please turn off your camera. I request the August gathering gathered here today to witness Mr. Salman Khurshid. Since this is a virtual platform, it would be better if we turn off our camera. Mr. Bipin Kumar, please turn off your camera. So while in session, I would request everybody to turn off your camera so that on the screen there will be only Mr. Salman Khurshid. Thank you. Mr. Jishan Alam, please turn off your camera if you're listening to me.
Thank you.
I request everyone to please turn off the camera, put your microphone on mute. Nobody should, turn on and turn off your camera. It's actually not getting very, we are not getting very good pictures. So, Safa Khatun, please turn off your camera. Kutubin Qureshi, please turn off your camera. I'm requesting everyone to please turn off your camera and put your microphone on mute. Thank you.
We are muting it from our end also. So if even at the end of the session when you are supposed to ask the questions, you are just supposed to post the comments. That's it. You are not supposed to switch on your microphones and ask him the direct questions. And
Miss
this is
Safa,
final.
Miss
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 Safa
Safa,
Khatun,
yeah.
Miss Safa Khatun, please switch off your camera. If you're not able to connect, it is there in the bottom of your screen, right side.
Siddharth, you recently joined us. Mr. Siddharth Sharma, please turn off your camera. You're not supposed to turn on your camera.
Siddharth, if you are hearing our voice, please switch off your camera. We are advising not to switch on your cameras. Thank you. Aman, please switch off your cameras. Please do that.
रुपी चला गया है तो इसका बताओ।
I, on behalf of the entire Legis Orbis family, welcomes Shri Salman Khurshid to our first webinar series. I now request Salman sir to please address this extraordinary virtual gathering over Google Meet and YouTube Live. Sir, over to you.
Thank you very much. It's wonderful to be connected with you. See, we have a little issue here. Yeah, okay. देखो भी कुछ गड़बड़ हो रहा है सीसी का होगा क्या इसका होगा ना कोई फिर कोई प्रॉब्लम होगा ना कुछ नहीं हो रहा दोबारा कनेक्ट करो कभी क्या करो पता नहीं आपने क्या किया से आएंगे नहीं क्या करेंगे यहाँ के लिए काम नहीं कर सकते क्या करता है वो कौन है बटवारा क्यों नहीं ठीक करता है किसको देते हो काम यार सर एयरटेल वाले नहीं अभी इस वक्त नहीं चल रहा है ये इस वक्त बिल्कुल नहीं चल रहा है
It appears that there is some technical problem at the end of Mr. Salman Khurshid. We will be joining. Sir is there again.
Hello? Hello?
You're audible, sir. You're completely fine, sir.
All right, you're fine, but I can't see any of you anyway, so I'll start speaking. We'll finally get there. I don't know what the problem with the connectivity is. But
So just for the sake of clarity, we have asked all of our participants to switch off their camera. That's why they
So
are.
that you don't face any trouble, sir.
is that a threat or is that a promise?
Promise.
Okay. Listen, I was hoping we would be able to talk about something far more interesting than what you have asked me to speak about. But this is a current and this is a live topic, and therefore I'll try and give you my mind on this. And then if we get on to something else, we'll talk about that. I've had two appearances today. One Bombay High Court and one in the Supreme Court. every court is doing this digital online appearances in the best way that we were able to figure out in the few months or few weeks that they've had a chance uh, to work out the processes and procedures. But a lot of people who are appearing in online cases are coming back with somewhat disappointing assessments, saying that it's fine as an emergency thing, it's fine that we have to do it while COVID lasts, but this cannot be the new norm. This cannot possibly be something of a permanent nature as we move forward. And that's an understandable thing. So let us look at the different dimensions of this. One is, what does this have to do with slowdown? Are the courts slowing down because they are relying on digital processing and digital procedures, or the courts are slowing down because there's a general ambience in the country that we should shelve everything and concentrate on those things that are life and death matters, frankly, in times of COVID. So there are emotional things, there are strategic things, there are practical things, etc., because of which one might feel that there is a slowdown. Because not all courts are sitting. It's few courts are sitting where there could have been more, and that perhaps has something to do with the infrastructure that is available. It also has something to do with how well people are equipped, how well people can make presentations in through a mode that is relatively new to a lot of people. Perhaps Delhi, Mumbai, Calcutta, there will be a few people who are accustomed to it. But I am told by colleagues from Allahabad, for instance, Lucknow, for instance, that there are many lawyers who are completely puzzled and have no idea at all how to go about doing digital appearances. So there may just be two ways of looking at it. One thing is to treat it as a pure emergency, and thank the stars that we have at least available some platforms that can quickly be put into the service of online appearances and online courts. So, I mean, if this had happened maybe 2 years or 3 years ago, we would not have half the facilities that are today available. I mean, I don't know whether webinars, which we have now become quite accustomed to, or for that matter, corporate conferences that we are quite able to do, or at home using technology, telephony, to communicate with each other in a manner which is far more exciting and substantive than it was barely 3-4 years ago, 5 years ago. So that's one thing. That's one thing. The second thing is that we see it as an emergency, and therefore we treat it as an emergency. We treat it as an emergency, saying we'll do it if it really requires to be done, or we will just postpone it for some time to come. Now, what's happening is that courts are disposing of small matters, admission matters, small matters, where stays are required or some immediate intervention is called for. But very long cases that would go on for hours, if not days, in the Supreme Court, for instance, that is something that is not being experimented with. The maximum benches that we have seen are of 3 judges. I'm not quite sure that anybody will in a hurry see a constitutional bench of 5 judges. May happen. But certainly I can't imagine 11 judges and 15 judges would be able to sit together before we are able to master, as it were, this telephony and modern technology. So one dimension. The second dimension is that we are using platforms that are available, that everybody uses, are the platforms that we are using. We're using webinar, we are using Zoom, we are using video in the Supreme Court, we are using WebEx, Cisco's WebEx, etc. But we are not using technology that has been developed specifically for online courts. And it isn't that that's not there. I mean, in the Delhi Supreme Court, for instance, when I was Minister of Law, had invited me to come and see the digitalization they had done, how they were converting the registry into a digital registry, how judges didn't have to carry files home. They could just on a pen drive take 30, 40, 50, 60, 70 files home and bring back the pen drive. And that was software that had been specifically developed by judges, for courts, and therefore obviously had a lot more going for it than borrowed software or borrowed platforms that we are using across the country in various high courts and lower courts today. So if we are to continue dealing with, for one reason or another, if we have a high level of approval, if we have prolonged lockdowns because of the kind of things that are going on, etc., we'll have to obviously start working on instruments and platforms and software that is specific to the legal system, that is specific to the judicial system, and specific to administration of justice. The Supreme Court has made a big start. They have introduced a comprehensive e-filing. E-filing was done in parallel with physical filing. That's done elsewhere in Allahabad High Court as well, I believe. But e-filing, where you are completely and entirely free of any paper. So the paperless filing, paperless offices, paperless appearances is something that will now happen and will be very welcome. And of course, that means that there's going to be, things are going to work faster. Today, for instance, if the High Court has to direct that the lower court record be sent for, it had to be brought physically in bundles. It had to be brought physically. And obviously that takes time. You have to get the record together, put it into a bundle. You have to transport it across to the High Court. The High Court registry has to unbundle it, put it down in some form, etc. And if there are lawyers who want to inspect that, then that inspection is to be allowed by opening of the bundles, etc. Now, with e-filing, as it filters down all the way to the trial court, so on the press of a button, the entire record will be available, or any part of the record that you require. So the filing, the actual filing itself also, in terms of appeals or in terms of any other proceedings like revision, etc., will just have to be a few pages, because everything that you need would be available because of the electronic file that is in the system. Now, that's not going to slow things down. That is going to speed up things. So everything that we've been accustomed to, and by way of lackadaisical, slow, endlessly waiting for things to happen, will now not happen because of what is in store. But of course, we need to apply our minds and to ensure that this is done quickly and effectively. And an entire grid that we have in mind for the whole country, an entire grid of cases would be available through servers and through centralized systems. So that's going to speed up things. That's not going to slow down things. On the other hand, if the system becomes acceptable to lawyers and litigants, and there is a higher level of confidence that than you might have today, you'd certainly have to be certainly have to be looking at something completely new and different, in the sense that people who are in far off places would be able to, buy on an option, of course, both sides have to be able to agree on this. So instead of you're getting your lawyers from a small city or whichever place there are some courts to the capital city or to a place where you have other lawyers who are far more expensive, and you may have less confidence in them because you've spent little less time being able to communicate your concerns to the lawyer. And therefore, in such a case, you would be able to be present and the matter would be argued from wherever you are. It could be from any of the high courts. There could be e-courts, or there could be studios for online appearances in the Supreme Court. So instead of coming from Bangalore or from Chennai or from Kerala in an appeal to the Supreme Court and physically travel to the Supreme Court, the filing could be done there, the arguments could be done there, and the electronic courts here in the Supreme Court could sit and in a dedicated manner hear things from each of the high courts on particular days or at a particular time. And that would be not only an enormous saving in terms of money, but it also will be an enormous convenience in terms of not physically having to move from one place to another, carrying records, carrying files, etc., and the fear and the danger of losing those papers en route or in travel. So I think that should be a very promising future for litigation in terms of your being able to reach the highest court, or in a state, reach a high court far away from the district to which you belong. And it'll be interesting how we change our way of life or of functioning or of our professional conduct when that happens. I have an interesting side to mention here. In all the matters that I have been appearing, it's almost like watching a film, because you see on the screen, very close by, you see your counterpart, the opposing counsel, appear, and you see their face very clearly. Every grimace, every smile, every gesture, every wink, you can see very clearly. But what's more important is that arguments that are faulty, arguments that have holes in them, look as though they are they're being magnified in front of you. Something that in a hot and humid, congested courtroom would be lost. Here, it comes staring you in the face, almost like when you work in films or you work on television, and then you are told that any little twitch gets exaggerated, any expression or the use of a particular tone of voice, intonation, cadence, etc., all get exaggerated when you're on a large screen. And unlike in a crowded place where you are having to raise your voice, you're trying to reach out above somebody else who's saying something else, etc., which is unfortunately what we see sometimes in our courts, where decorum breaks down. Courts have to constantly remind lawyers that they are in a court of law and that they must be at their best behavior in a court of law. So these are interesting things that will happen when we get accustomed to electronic proceedings or online proceedings. I certainly think that right now there is a disadvantage. A lot of judges at the other end, I haven't seen lawyers so much, but judges at the other end, i.e. judges on the bench, many cases wear masks, and for obvious reasons, for reasons of safety and security in the present system. But the judges wearing masks also mask their their face. When you have a conversation, you need to look a person in the eyes. When you have a conversation, you need to see each person's expressions in order to judge how effective you are being in what you are saying. And now with judges sitting there on a screen with a mask, it's very difficult, particularly if they're sitting some distance away from the screen, which is often the case because the cameras are quite a distance from them when they sit up on the benches. And it appears that they are remote enough not to give any indication in terms of a response to their to what is being argued. Therefore, whatever young lawyers have learned in their moot sessions in different law faculties, law schools, will now have to undergo a tremendous change, tremendous new technology will be bringing in a lot of new techniques for you to be able to argue your case forcefully, unlike whatever one has traditionally under the conventional methods learned. And I think that's certainly quite interesting. But a lot of people tell me, and I have no experience of this yet, but a lot of people tell me, what will you do in long cases? In long cases where you have to go on for several hours. Can you hold somebody's attention on a screen in the same way as you hold their attention when you are actually physically present in court? Big question. Then, of course, there are issues of trial courts. Trial courts, which includes the high courts, where the high courts have a trial. Demeanor of witnesses is a very important factor in trials, particularly in criminal trials, to decide whether someone is telling the truth. When the cross-examination happens, it's not just what it looks like on paper, but also the demeanor in the cross-examination, which is very important for the presiding officer, the presiding judge. How will that be affected is a big question that people are asking, and I guess only time will answer that. We have no way of telling. Except there are people who are experienced, people who have who've used technology in litigation, etc., and therefore will be able to supplement our understanding and knowledge. But I think that it will still take some time before we are fully equipped to deal with this. And then again, what happens when you have thousands of pages? On the day on which the electronic filing modules were presented by the Supreme Court, Chief Justice Bobde was present and Justice Chandrachud was present, who had steered the preparation of the e-filing modules. And Chief Justice Bobde said that, we are thinking of cases like the Ayodhya hearing, in which there were thousands of pages, 30 volumes, 40 volumes, that have been prepared after enormous effort. And those 30, 40 volumes had to be kept ready for the entire bench, which is 5 judges in that case. It could be even a larger bench in some cases. And the fact that there were 30 volumes or more and thousands of pages was bad enough. But what would you do if all those 30 volumes have to be on the screen, or have to be on a computer, and they have to be culled out and have to be made available? And how are you to turn from volume to volume? Now, of course, there is software that allows you to do so, but when you go into large volumes, then it becomes very difficult electronically if you're not very, very well equipped and not very, very well trained to be able to quickly go from page to page. And there, of course, Chief Justice spoke very promisingly about artificial intelligence being the next step. But once you've done electronic filing and you get accustomed to electronic filing, artificial intelligence will also be inducted. I do understand that the SCC people are already fairly advanced in the state of using artificial intelligence for law research, and therefore artificial intelligence used in the appropriate way for the filing system is going to be a remarkable change for all of us. Indeed, just as the law reports being computerized and law reports being available online have made such a remarkable difference to the quality of research and quality of presentations in court. So none of this is going to be on the deficit side, as it were. None of this will be on the slowing down side of the legal system. Will indeed be on enhancing the speed with which this legal system will respond to anything that comes before courts of law. And therefore, our fear that the electronic systems will slow it down is wrong. If an impression that's gathered from the system as it's operating now is that there will be an inevitable slowdown, then I think that it's wrong. It's an impression based entirely on the fact that we were unprepared. We were talking about moving to paperless systems, and we were often talking about how other courts in other countries have achieved that. Brazil, for instance, has achieved paperless legal system. They have achieved it, and there's no reason that they can. And a country which has special expertise in software and in computer hardware, like our country, India, cannot achieve it. And I'm sure that in due course we will be at the forefront of all this. But sometimes people bring to fore one critical question, and that's the question of the digital divide in our society. The caliber and quality of people who have access to modern technology and equipment, which includes, of course, the judges, but is not something that is available or will be easily available to everybody. Of course, if you look at smartphones and the penetration of smartphones and smart telephony, we made an enormous jump, or a leap, if you like, in inclusivity, in getting people into a wholesome, holistic world of technology. But that's still the lean end, the heavy equipment, the heavy and the real expensive equipment is only accessed by a limited number of people in relative terms. And how will we be able to overcome the digital divide is a big question. I'm sure that people who are in electronics are seriously thinking about it. There have been some false starts that we've made over the years, particularly in the field of education, when we've tried to make laptops or very inexpensive, not iPad kind of things, but similar equipment. But that's not really taken off, and they kind of fizzled out as sort of stillborn children of the electronic age. But this is something we'll have to seriously think about. So the problem, as you formulated the topic of the day, was not about slow down or slowing down of the system, but I think it's of not leaving some people behind, that some people should not be especially disadvantaged because they cannot afford the electronic equipment that is accessible and available to people who are affluent or who are rich or who are better placed than most of them. And there is, I believe, not enough data available. I mean, there is poverty data available in the country, but there is not enough data, I believe, yet on what kind of digital divide there would be between people who have and can afford the best and those who have the capacity to utilize it because they've reached, at least they've reached that level, but they don't have the ability to be able to access equipment and be able to buy equipment. And I went to a law school in the UK after many years, and I remember in my time that law school picture used to be a huge number of bookshelves and people were reaching out to volumes, bringing them to the desk where they were working, and then putting little slips into to read, etc., etc. And of course, a lot of textbooks as usual. I suddenly found this time in recent years that I have been to law colleges, both in India and abroad, is that you don't see a book at all. Everything is on computers. So everyone has a laptop, and you have these hundreds and thousands of laptops open in the library, and the books are just sitting pretty as a little bit of history, as it were, of how we learn our law. And therefore, this change that's inevitable, the change that's coming, must not exclude or leave behind someone, is a concern that we must have and we must find answers to. And that we must design the legal electronics for people who understand, and who can use it to the maximum and not handicap them in any manner. So that virtual courtrooms will become not just like the courtrooms we used to have, but will become courtrooms of the dreams that we've had of effective presence, hearing structures and effective infrastructure for a rapid and quick response to the problems. And I think that when judges sit to decide something, everything being made available to them, some of the outstanding judges today use their own iPads and use their own ability to seek information, even while they're hearing matters in the courtroom. But this should become the new norm. The new norm must not be that everything gets delayed, everything gets more frustrating because of the wait that one has to do, and that whatever answer you want from the system, a response you want from the system, getting to take years must not happen. I think it's completely unacceptable that in ordinary civil cases, you have to wait for 20 years to get anywhere. That in criminal cases, you have to wait for 20 years to finally be told that you were wrongly charged. I think this is something that we need to find a solution to. And that solution will lie in electronic virtual court systems, but not by episodic development, not by under pressure, gun to your head, so you have to get in front of a computer and decide cases, but in a structural, organized, meaningful manner. This is the life of tomorrow, and we should neither resist it nor surrender to it without applying our mind. And we should apply our mind in a manner in which we use it to elevate whatever we are doing, to escalate whatever we are doing, and to exhilarate the product that we get out of it. And that's really how I see it. Now, if you have questions, I'll be very happy to answer questions. If you want me to go on to another topic, a topic of greater interest to me, which I believe has to be handled whether you are doing law electronically or you're doing law in a conventional way, and we'll get back and talk about some of those topics. So thank you, and then let's see if we can get questions from you.
If anyone is having any questions, it might be posted in the comment section of the chat. So would be addressing those questions. Anyone is having any questions, it can be posted in the comment section.
Okay, I saw one question about law institutions that need to be autonomous, independent. Why do you limit yourself to law institutions? What about institutions per se? Independence of institutions. And people often say that you've heard recent criticism of the Supreme Court by some former Supreme Court judges, by some very, very eminent lawyers, and by some other people, saying, is the Supreme Court looking too much towards the executive? Is it becoming a court of the executive? Now, it may be perhaps unfair to say, to expect of a court in very difficult times to intervene and deliver on issues that it is not very clear about. It's not very clear about. For instance, let's look at what was happening at the beginning of COVID, or still continuing to happen. What about judging people as to the systems that have been put in place for ensuring that more people don't get infected, or for ensuring those who are infected are cured, or those who have lost their jobs want to go home, and whether enough has been done for them. Now, I believe there's a hesitation in such times for the court, because the court feels it doesn't have enough information, that it doesn't have enough knowledge, or it doesn't have enough capacity to deal with something of that nature, and therefore it may be a little bit hesitant. But when it finds that something is going severely wrong, it steps in. And it steps in, as the court did for the migrant labor, to say, well, we thought that you might have known what is best, but since it's not working out, I'm afraid we have to step in. And then the court then steps in. There'll always be hindsight in these matters, where you might think that you could have done more, and in hindsight you might think that what you did was wrong. But I think all this is part of a learning process. The court has so much to learn when such extraordinary situations, extraordinary things happen. We all have to learn. So why should we be surprised that the court has to learn? Never given a breather. It wasn't given even. People say that the lockdown was declared at 4 hours notice. Nobody was given any time to organize themselves or to take stock of what they needed and required, etc. And that's the reason why much of the chaos happened. Well, it might be said for the courts as well, that the courts never really had the time to respond to what was happening. One day they were hearing matters, and suddenly the next day everything was closed down. So I think we should give them credit for picking up as they go along. And at the end of the day, I'm quite sure that the courts will show that they remain independent. In any era, in any time, under any regime, there are some judges who are more independent, seemingly, some who are less independent, but that's part of the human existence. I mean, that can be said by any one of us. Some of us are followers, and some of us are leaders. And a leader will remain a leader, and a follower will remain a follower. So there are judges who lead, there are judges who follow, there are judges who disagree, there are judges who write dissents, there are judges who follow the Chief Justice because they believe he knows better than many of them. So it's only in due course that you will get to know. as to who made the right decision and who made the wrong decision. So you'll have to repeat the questions that were coming so that I know which one to answer.
So I'll moderate it for you. One question was, so the new normal of litigation seems to be silent about the internship opportunities for the law student in advocates chamber. How would you address them?
Well, you know, I get a lot of requests every month. Sadly, because of COVID and the closing down of courts, at least of actual physical functioning of courts, we had to suspend the internship program. But I do believe that there are many good internships that are made available by law firms as well as by chambers. But there isn't a kind of collective decision about what should be expected of interns and what in turn the interns should expect of us. I think that the law associations must come together, the bar association, bar councils come together and work out certain broad parameters so that we can make life of interns more comfortable. I believe there is a great difficulty about interns being able to see what's happening in courts, particularly on Mondays and Fridays, as far as the Supreme Court is concerned. So I think now that we are breaking the barrier of digital hearings, we'll also break the barrier of court proceedings being shown, at least in closed circuit manner, if not publicly, so that there would be more commodious and comfortable way in which interns can get the benefit of court hearings if they can't actually physically get into a courtroom.
So another question is, as government is going to decriminalize several sections, one of them is section 138 of NI Act. Please put your view on this section. It should be decriminalized or not.
See, I'm afraid I'm a person who believes that the government should have as little to do with the people in a democracy, and certainly criminalizing their conduct in different manner is something that prima facie I'm against. I believe that what happened with the judgments, both first of the High Court, then of the Supreme Court, in the case of differently sexually inclined persons, LGBTQ, Justice A.P. Shah's judgment in the High Court, and then the Supreme Court rejecting it, but then finally in review, hearing the matter again and coming to a conclusion that this should be decriminalized. I think there is too much of criminal law used for unsavory, unwelcome, and bad behavior. But we must have other ways of dealing with them. Incentivize, de-incentivize, etc. may be the ways to deal with them. I don't think we should criminalize everything. And I think the manner in which the criminal law, for instance, is used in the home, the manner in which criminal law is used in ordinary business transactions, where things can go wrong, and getting otherwise honest businessmen, respectable businessmen, to have to go to prison or to repeatedly go to a criminal court, I think should be avoided. But I do realize that there is misuse of transaction both ways. The giver and the receiver both are people who misuse them. We must think seriously about what alternative ways there are. And I think alternative ways can be found.
So the third question is, what would be the scenario of applications of Surfacy Act in the upcoming times?
Well, I think all the legislation relating to financial accountability will have to seriously be looked at, because I think for the next 2 years, maybe more, there is going to be a lot of uncertainty in the marketplace, and a lot of uncertainty as far as people's finances are concerned. It will happen in the real estate sector. It was already happening before COVID pandemic set into India. But I think that we'll have to restructure our economic laws very carefully for the next 2 years. Perhaps introduce moratoriums of kind. Perhaps give some relief in places which are very critical, keeping in mind ultimately that the economy must get back on its feet as quickly as possible, and that anything that prevents from the economy from getting back on its feet might be a bad idea to implement during this period, and that includes surfacing.
So the final question is, what's your suggestion for the final year students regarding career opportunities during this phase?
Well, frankly, you're asking me a question about what will happen to all of us tomorrow, or a week from now, or 2 months from now, etc. We don't know. Nobody knows. But I just want to give a word of assurance, and the word of assurance is that life will get back on track. It can't but get back on track. It will happen as soon as the cure is found. It will happen as soon as the vaccine is found, because not only is there a problem with the disease, but there's also a problem with fear. If we can get rid of fear, but without compromising on the requirements to protect ourselves and to protect society, we will be quickly back on our feet. And I think it's important that we have faith and we believe that we will be able to get back on our feet. It may, for young lawyers who are coming out of the system now, of their training now, it may take a little bit longer than it usually did, but then everyone's going to be moving a bit slow, so you won't be left far behind.
So we have one more question. What is your viewpoint on the amendment in section 124A of Indian Penal Code, that's sedition?
Well, I've already said to you that I'm against criminalizing things, unless it's necessary. Obviously, I'm not against criminal sanctions for murder. I'm not against criminal sanctions for rioting, etc., etc. But I think we must learn to be a little more confident about ourselves. To be touch me not kind of country, and to be afraid that somebody makes a nasty speech and that will destroy everything in the country is showing very little faith in the country. We are very robust, we are very strong. A few speeches here and there are not going to destroy our sovereignty, are not going to destroy our standing. And I think we should know and we should learn to take them in our stride. I don't believe that we should rush into making a criminal prosecution situation out of things which are unsavory, unwelcome, are irritating, are unwholesome. But I think we must have ways of answering them rather than resorting to criminal law to protect ourselves.
So we have a longer question this time. Extraordinary times call for extraordinary measure. Gradually, this path is being adopted by many state governments in India by relaxing the labor laws to woo the business enterprises. But the question lies whether the economic progress shall prevail over the health and security of factory workers. Now, at the same time, the question also arises, how do you see the development of labor laws along with labor welfare scheme in the post-COVID era?
Well, frankly, I mean, this is a matter of political choice. I'm not sure that everyone's come out clearly on this, but I do believe that the times require, for instance, an imperative for us to ensure that the poorest of our society are not damaged beyond repair. And therefore, this need to give them support, physical, financial support, is very important. And I do believe that the Mahatma Gandhi National Rural Employment Guarantee Scheme accepted by government as a possible way out, not the only way out, is to be welcomed. I think it's a great idea. Similarly, I believe that the middle classes in this country can't be left on their own to nurse the economy back to good health. We must do something. I mean, we may not be able to do what England has done, for instance, in providing the paycheck protection program. Perhaps we can't do as much as that, but at least to some extent, you need to protect middle classes as well, because ultimately the thrust of reviving the economy will come from the middle classes. What the labor class and the working class can do is to buttress it and not become a burden by given help at this critical stage. So they are important, and the middle class is important. And then, of course, people who invest, people who run industry, people who provide jobs are important. So you've got to have a balanced attitude. You can't just choose one over the other. Yes, please. Yes, I can see you all. I can see Rashri there. I can see you all. Yeah.
Yes, sir.
So you're now in practice already?
Sir, I'm appearing for judiciary.
Oh, how wonderful! How wonderful! That's excellent. That's excellent. We need good, bright, attractive judges, and that's wonderful. Wonderful to know that.
Thank you so much, sir.
I saw in your description a whole lot of LLM gold medalists, and I thought, gosh, they're all gold medalists. What are they doing now? Okay, very good. Excellent.
Thank you so much, sir. Sir, thank you so much. First of all, good evening, everyone. It's my privilege to have been asked to propose a vote of thanks on this occasion. I, Rajshri Kanungo, on behalf of the entire Legis Orbis family, extend a very hearty vote of thanks to our guest of honor, Shri Salman Khurshid, who blessed us with his presence and took out valuable time of his busy schedule. Sir, I would like to thank you for gracing today's webinar and delivering the inaugural address. I think and I'm sure that all the participants have taken a note of your suggestion and will be determined to take the action to be initiated at their level. And lastly, I would also like to thank all of our participants to make it a grand success and make it a voteful one. Thank you, everyone, from the entire Legis Orbis family.
But thank you very much, and good luck to all of you.
Thank you so much, sir.
All the best. Okay. Bye-bye. All the best. Bye.
Thank you so much, sir.
Thank you.
Thank you, sir. Thank you.
Thank you. You are muted.
Am I audible to you?
भैया को ठंडा दो यार
Shri Salman Khurshid with us live from New Delhi. On 20th of June 2020, we will be live again with Mr. Ashok Arora, the Secretary of the Supreme Court Bar Association, the Senior Lawyer of Supreme Court of India, a renowned speaker, author, and a law teacher. Thank you all for joining us. This is Legis Orbis' first webinar series. Thank you all for your cooperation. Thank you very much.
Thank you, everyone. Stay tuned.